In 2013, I was approached by Lock the Gate and asked to be involved with an evaluation of the groundwater impacts of the proposed Galilee Basin mines. I initially refused that, and I said, no, go away. I don't want to get tied up with a mob like you, and I'll just stick with my consultancy work. And a couple of my friends in the pastoralists out in the Galilee Basin heard about this, and they rang me up and they said, we hear that Lock the Gate are trying to get you involved in Galilee Basin. I said, yes, that's correct. They said, we think you should get involved and help them and put some facts into the debate and deal with the facts. And so I reconsidered that, and I talked to Lock the Gate, and hence I became involved. We developed up, I was a co-author of a report called Draining the Lifeblood, and it's the first report which has really looked at or attempted to quantify the potential cumulative impacts of all proposed mines, the 9 mines for the Galilee Basin. It was prepared in response to the Bligh and Newman government's failure to consider the cumulative impacts or what the impacts of those mines would be on the regional groundwater resources. The report was developed from information which was publicly available from consultants' reports which had been prepared for a number of mines, and where we couldn't source consultant reports, we did some extrapolation to look at what potential water take would be taken through dewatering operations. Now, the previous Deputy Premier suggested we'd pluck these fingers out of the air. Well, we didn't pull them out of the air or out of our back pocket. We got them from consultants' reports and built on that. If all 9 mines go ahead, there'd be more than 34 mine pits and over 9 underground mines along a 270-kilometre north-south strike. The initial estimates of dewatering impacts of 4 mines conditionally approved was 1,375 gigalitres of groundwater over their mine life. That's equivalent to in excess of 700 years of livestock and domestic supplies for the local grazing industry. Just think about it. 700 years of water will be taken out by these 4 mines that have been conditionally approved. Furthermore, when we received more documentation through the EIS and SEIS process for the approvals for these mines, the water extraction was upgraded from 1,375 to 1,770 gigalitres. That's 3.7 Sydney Harbour. Also, from the reports, the consultants' reports, the annual water use by the initial 5 mines proposed was between 50 and 70 gigalitres per annum for activities like coal washing, dust suppression, camp supplies. That is all what we call non-associated water in the industry. And to that end, the Queensland government proposed to take 130,000 megalitres of general reserve water and 20,000 megalitres of strategic reserve water from the Burdekin Basin, from the Burdekin Dam, unallocated water in the Burdekin Dam. And to that end, Galilee Water, a company which Keith DeLacy's involved in, were looking at potentially taking water out of the Camp and Campaspe rivers to divert down here for those surface water supplies. The consultants have proposed that a groundwater cone of depression, that is a lowering of the groundwater, will extend 30 kilometres wide and up to 100 kilometres long from the dewatering of these mines. They also projected reductions in the order of 5 to 70 metres in the levels of groundwater on landholders' properties. Initially, some 39 properties, and I think we may need to revise that up, but some 39 properties involving 168 land parcels within those proposed 9 areas of mining, and they could be expected to have significant impacts to their groundwater supplies, from reduction of levels to total loss of groundwater. Over 500 bores, 200 within the mine leases, and a further 300 within 20 kilometres of the mine leases will potentially be impacted. This is the lifeblood of the local landholders. They rely on their groundwater for their stock and domestic supplies. There's still a very wide diversity of views of whether these mine proposals will impact on the Great Artesian Basin. The independent expert scientific committee set up by the Commonwealth Government to advise the Federal Minister believed that these mines will have significant impacts potentially on the GAB, in which when they collapse the longwalls, underground mines, they will fracture the Rewan formation and cause drainage of the GAB to the east. The mine consultants, all of them, say no, that won't happen, but we need to bear in mind that those consultants are preparing a report for the proponent, and they're not hardly going to suggest that something as emotional as the GAB is going to be impacted. Our report found that there's a high risk for the Rewan formation to be fractured through these activities. Recent developments. Since the Alpha Land Court decision, the Newman government gave conditional approval for the Adani Carmichael mine. That's the biggest mine proposed in the Galilee Basin and the biggest mine proposed in the Southern Hemisphere. Huge mine. The impacts of the Adani mine could include 750 gigalitres of groundwater could be extracted by dewatering operations. 36 landholders could have their bores impacted. Significant impacts to the bores on Melaleuca property, Bimba East property, Lignum and Moray Downs, and drawdowns of between 1 and 85 metres. Potential impacts on the groundwater-dependent ecosystems in the Galilee Springs complex and the Melaleuca Springs complex. Potential impacts on the riparian flows in the Carmichael River. So we could have reduced riparian flows in the Carmichael River. Predicted impacts on the Melaleuca Springs complex could include Melaleuca Springs, 1 to 9 metres drawdown. Story Springs, 2 to 13 metres drawdown. Lignum Spring, 8 to 26 metres drawdown. Melaleuca Springs complex will cease to flow and dry up. Adani proposed to do nothing about those impacts. They proposed to let the springs dry up. Predicted impacts on the Carmichael River are base flows supported by groundwater discharges in the creek are going to decrease. At least 65 springs provide base flows to the Carmichael River. Predicted drawdown of 1 to 4 metres in the immediate vicinity of the Carmichael River, in the aquifers associated on either side of the Carmichael River, 1 to 4 metre drawdown. Carmichael River base flows could be reduced by 1,000 cumecs a day, a reduction of 66% of the pre-development flows in the river. Zero flow periods in the Carmichael River will increase between 30 and 60%. The time that you get zero flow. Impacts predicted to extend 10 kilometres upstream and 25 kilometres downstream in the Carmichael River of the Carmichael mine. Impacts on riparian vegetation. River red gums and paperbarks may experience dieback or dieback from the drying out and reduction of water along the Carmichael River. So what are the key water-related concerns with the Galilee Basin mines? Well, the Coordinator General has 5 mines approved without fully considering their cumulative impacts. He's assessed all of these mines independently without looking at all of the impacts added together, what that's going to do to the regional groundwater resources. He's highlighted each time the need to develop a regional water balance model and an assessment program for each mine. So he keeps saying we need to develop this and we need to get some money from the mine proponents to develop this model, this hydrological model, but nothing's been done. The Federal Environment Minister has also set requirements for Clive Palmer's Galilee Coal project, and those requirements are to develop a water monitoring and management plan and to undertake a connectivity research plan for the geological formations associated with the Great Artesian Basin. So he wants to have a look at what is the connection between the Rewan formation, which is associated with the Great Artesian Basin, and the clematis sandstones and the other sandstones which will be impacted by mining. Undertaking these actions after the granting of environmental approvals is just like shutting the gate after the horse has bolted. Bit hard to do this, and it's interesting that in each of these conditional approvals, there's a host of conditions this long. In the last one, the Palmer one, there was over 130 conditions. Conditions are only as good as the department that enforces them. Recently, the Auditor General did a report into Queensland government departments. His report was scathing about, he virtually branded them incompetent in terms of their monitoring and enforcement of conditions associated with environmental authorities. Fairly concerning. A regional groundwater model, hydrology model, is an essential tool for a hydrogeologist or for a water planner like myself when I was in the job in assessing the cumulative impacts of these proposed mines on the groundwater resources, the aquifers of the Galilee Basin. It's also a critical tool in assessing whether this take of water is sustainable or not. Remember, we're talking about 1,770, nearly 2,000 gigalitres of water being taken out of the system. To date, the Queensland Government has taken no action whatsoever in developing a regional groundwater hydrology model for the Galilee Basin. Or if it has, it's still locked up in the cupboard. It's not disclosing it. But it still promotes its unqualified endorsement of the sustainability of the Galilee Basin mines. Only a week ago, Minister Lynham was telling everybody that the Galilee Basin mines are sustainable. Well, I'm sorry, he has a different definition of sustainability to me. The Queensland Government has asserted that a rigorous independent assessment undertaken by the Coordinator-General has ensured that the Galilee Basin growth will occur in an environmentally responsible manner, and that Queensland has world-class standards when it comes to environmental approvals. Well, I'm sorry, that's not true either. The approval of the Galilee Basin mines without considering their cumulative impacts is definitely not a world-class standard of assessment. Definitely not. The Queensland Government asserts that the Warola legislation, the Act which was pushed through the House on the 26th of November last year, allows water authorities to dewater new coal mines, and that will also compel mine operators to sign make-good agreements with landholders to remediate or compensate for any loss of groundwater caused by mining. So they were putting all their eggs into the make-good agreements basket. The make-good agreements being offered to Galilee Basin landholders are being negotiated on a very uneven playing field. You'd almost say that it had bomb craters all over it. It's so potholed, and it's quite unfair. For example, GVK Hancock's MGAs do not comply with the conditions stipulated by the Coordinator-General in respect to definition or identification of unduly affected bores or the standard dispute resolution procedures. So they don't even comply with the Coordinator-General said in the conditional approval. Furthermore, the make-good agreements invariably contain one-sided provisions, including the imposition of compulsory and total confidentiality clauses, the inclusion of a force majeure waiver, allowing a mine operator to cease water delivery in the event of, listen to it, lightning, storm, flood, drought, fire, earthquake, explosion, or even adverse weather conditions. Now, strike me lucky, that's exactly when landholders need an assured water supply, in adverse weather conditions and drought. But here's an agreement from a mining company trying to exclude themselves from delivering water in those conditions. The agreements also give the mining company the sole right to determine if it is the cause of the water supply problem. I mean, this is unbelievable. And it also contains no provision for ensuring landholder water supplies are provided for post-mining. Once they walk away, that's tough luck for the landholder. That's what those agreements have got. So the comment I make is the Queensland Government has not ensured Galilee Basin landholders get a fair go when dealing with the huge mining corporations in negotiating make-good agreements. Just not good enough. When I raised this publicly, I was branded by the ex-Deputy Premier as being an extremist greenie, an alarmist, a patronising greenie, and that I should mind my own business and let the landholders engage their solicitors and sort it out. Now, let's move on to landholders' actions and government's reactions. In 2013, 3 landholders impacted by the GVK Hancock Alpha mine and the Environmental Defenders Office lodged a Land Court action against the Draft Environmental Authority. In April 2014, the Land Court found that a more cautious approach to the approval of these new mines in the Galilee Basin is needed to protect the groundwater resources for all users. The Court recommended the Minister for Mines, Andrew Cripps at the time, that the Alpha mine be either rejected or that the mining lease be granted subject to GVK Hancock, A, first obtaining licences to take water from the aquifers for dewatering purposes, they would be Water Act licences, and B, that all concerns in respect to the proportionary principle be resolved. The Court also recommended that that 3 additional groundwater monitoring bores be constructed and that make good agreements be negotiated with the 3 impacted landholders either within 12 months or before mining commences. I can report that no such action has been undertaken to date. In response to the Land Court's decisions and recommendations, the Queensland Government granted conditional approval to Adani's Carmichael coal mine, the mega coal mine. They said, well, let's grant the approval. That was 3 months after the Land Court decision came down. The Queensland Government also passed the Mineral and Energy Resources Common Provisions Act, and that Act restricted the rights and grounds of objection to a mining lease. It also allowed the Land Court to strike out an objection to a mining lease or environmental authority if it thought it was frivolous, vexatious, or outside the Land Court's jurisdiction. The Common Provisions Act also provided that a submitter to an environmental authority could not use that submission as an objection to the granting of the environmental authority if the Coordinator General had set conditions to the environmental authority and was satisfied that those conditions adequately addressed the issues in the submission. So in other words, if the Coordinator General had set conditions and granted an environmental authority, any other previous objections or submissions that could not be construed as an objection. The other thing that happened too was that the Queensland Government proposed amendments to the Water Act and the Mineral Resources Act to grant miners a statutory right to take or interfere with associated groundwater. This is dewatering water, water which they need to get out of their mine pits or their underground mines to allow them to carry out a day-to-day mining operation. In progressing those legislative amendments, Minister Cripps made the statement that the Land Court's decision on the legal challenge to the GVK Hancock's Alpha coal mine supported his Water and Mineral Resources Act amendments to grant miners a statutory right to take groundwater. In other words, we had these 3 pesky landholders that caused all of this grief and drama by lodging a Land Court action, and that delayed the Alpha mine by over 12 months. So the way we fix that is we just grant a statutory right for Alpha to take the water irrespective. So that was the response. What has happened since? With the election of the Palaszczuk government in January, they placed a hold on the proclamation of these legislative amendments. The Palaszczuk government has until the 5th of December this year to either change or postpone these amendments through a regulation. However, just recently became aware that Andrew Cripps has moved a disallowance motion to that hold, and that will be considered on the House on the 15th of September. So on the 15th of September, the House will be debating a motion moved by Andrew Cripps. The Water Act amendments progressed last year in November, all be proclaimed and start as of a date to be determined. Since the Palaszczuk government put the hold on the proclamation of the Water Act amendments, they established a Water Engagement Forum to consult with stakeholders on proposed changes to both the Warola Act and also the Mineral Resources Act. The Palaszczuk government has also recently restored third-party objection rights through the removal of Section 47D of the State Development and Public Works Organisation Act. What needs to happen to legislation to improve things for landholders? The removal of the statutory rights to access or interfere with associated groundwater for dewatering purposes needs to be turned around. It needs the landholders' rights to object to that take of water need to be reinstated. There is also a statutory right for petroleum and gas operators to take as much water as they like when they spud in a bore or a well. And that should also be removed, because what we've got is we've got a situation where landholders are on a very uneven playing field. The only people that are allowed rights, statutory rights to access groundwater in Queensland at this point in time are petroleum and gas operators and mining operators. Landholders for stock and domestic purposes are also able to access groundwater, but any other water taken for production purposes has to go through a Water Act process. So it's a very, very inequitable situation granted to the resources industry and not to other people in Queensland. The final thing is we need to reinstate landholders' objection rights and appeal rights under the Water Act to the take or interference of water by mining and petroleum gas holders. We also need to retain and strengthen the make good arrangements for the petroleum and gas and mining industries, so they are both equitable and fair to landholders who have their water supplies impacted. We also need to remove the onus of proof on landholders to demonstrate that a resource sector's project is impairing their water. At the present time, the landholder has to go and demonstrate that that the mining company's activities or the gas company's activities are impacting on their water supply. We believe it should be turned around the other way. The mining company should be required to demonstrate that their activities are not impairing on the water supply if a bore has been impacted. We also believe there needs to be inclusion of predetermined triggers for remedial action. When the bore hits a certain level, some sort of action needs to trigger in. When it hits another level, an immediate action. No ifs or buts, there needs to be triggers in there which trigger that action. We also believe that the resources sector need to meet all landholders' professional costs for technical and legal support associated with dealings with make good agreements. At the present time, the way the Act's written is they'll pick up legal and accounting fees and evaluation fee, but they will not pick up the technical support for hydrogeologists or any other technical support. And that's ridiculous. The other problem that landholders have is that a lot of the hydrogeologists are actually being cornered by the resource companies. And when a landholder goes to try and find a hydrogeologist to advise them or support them in an action, very hard to find and very expensive to pay for. Some landholders have spent in excess of $120,000 in professional fees trying to negotiate make good agreements. Very easy to burn that sort of money. The other thing we need to put in make good agreements framework is the protection of landholders' water supplies post-mining or post-gas extraction. We also need to make sure that these are equitable and fair to impacted landholders. In terms of where we're heading now with this, the recent consultation with the Water Engagement Forum by the Palaszczuk government indicates that they're going to reinstate the ecological sustainable development provisions into the Water Act. They were removed previously. And they're going to remove the water development option, but they're going to replace it with something similar called a strategic water infrastructure commitment. So it takes one thing out in one hand and puts another thing in with the other hand. No other changes of any consequence are proposed to either the Water Act or the Mineral Resources Act. What does this mean for the Galilee Basin landholders? It means that if the Palaszczuk government are not going to take out the statutory rights for groundwater, that Galilee Basin landholders will be faced with consistent groundwater rights and objections for future mining and CSG projects. They'll both have the same framework. They can both tap into your underground water without requiring a Water Act authorisation. That's for dewatering or associated groundwater. Statutory rights to take groundwater for coal mining, dewatering or CSG will be automatically granted. Apart from being able to object to the granting of an environmental authority, a landholder will have no objection rights under the Water Act to the granting of the mine taking water for dewatering. The taking of underground water for use in fracking or coal washing, which is called non-associated water, will require a Water Act authorisation. And the government is also contemplating or proposing exemptions for low impact activities at small mines, very small mines. Haven't got the definition of a small mine yet, but that's what they're proposing. They're proposing because the petroleum gas industry are upset by their non-associated water requiring a Water Act licence. They're proposing to give them a 2-year transition period outside the Surat cumulative management area, and they're proposing to give them a 5-year exemption inside the Surat cumulative management area. There are also references to make good arrangements made by Palaszczuk government in their Water Engagement Forum document, but they are not proposing to address the current deficiencies in the make good frameworks. So a few of us are actually taking some other action there. There's also, regrettably, a possibility that any 4 of the current 4 Galilee Basin mines that have got conditional approval could withdraw their application and then resubmit it under new legislation, which would grant them a statutory right to take that groundwater. If they did that, they would automatically have that right to take the groundwater for dewatering. They would sidestep the need for a Water Act authorisation, and they would not be required to deal with any landholder objections to take that groundwater. They would just have that right to that water. The only other water they would need would be for the coal washing, dust suppression and that, and they're proposing to access water from either the Burdekin Dam or somewhere else for that. In wrapping up, the Galilee Basin mega mines were initiated by the Bligh government, progressed by the Newman government, and are still being endorsed by the Palaszczuk government. Both sides of the political fence are responsible for what has happened and what may happen down the track. It's acknowledged that in Queensland we need to develop our natural resources to sustain our quality of living us in Queensland enjoy. However, the social and economic benefits from the development of these resources should not be outweighed by the social, economic and environmental costs associated with their development. We need to keep it in balance. The lack of transparency, the lack of integrity, the lack of scientific rigour in assessing the cumulative groundwater impacts of the proposed Galilee Basin mines should not be overlooked, and nor should the lack of respect or concern or equitable treatment shown to the Galilee Basin landholders. That should not be overlooked and should not be allowed to continue. I think I will leave it to your wise judgment to decide whether the Queensland Government's assessments of the impacts of these mega mines on the groundwater resources in the Galilee Basin is a travesty or a legacy or both. Thank you very much.